of course, the partner swans in and, fronts the meeting or deals with the advocacy at the hearing. But everyone who knows the industry really knows that it's the senior associate that's like kind of the backbone of the entire operation. So I love that period. And I always tell juniors, that is something to look forward to. And when you get there, to really spend those years like honing your craft.
Welcome to another episode of our podcast series, ADR Corner AIAC on Air, the series that is designed to spotlight the inspiring journeys of seasonal and experienced arbitration practitioners and give the audience an intimate glimpse into their careers and trajectory in law. We are very lucky today to have Ms. May Tai. May is an independent arbitrator and the Vice President of the ICC Court of Arbitration. Thank you so much for doing this, May, and welcome to our podcast series.
It's my absolute pleasure. Malaysia is one of my favorite places to be in, so I'm always pleased to have a reason to come and visit.
We're very glad to have you here. To kick things off, usually on this podcast, we don't read out your entire resume or your background. What I would like you to do is, how would you introduce yourself to our audience?
Oh, right. Okay. Well, I'm a Malaysian national and I lived here till I was 11, and then I've lived in various places since then. I was in private practice, practicing as an arbitration lawyer for about 25 years. And then I made the decision to become an independent arbitrator full time. And that was a bit of a step change. I took about 2 years to fully change into an independent arbitrator, just because there's never any kind of good breaks in terms of your work as counsel. But I've done that now, so all my cases are as arbitrator now. And most of my career has been spent in Hong Kong, the UK, with some time also in mainland China and Singapore, Tokyo for a short amount of time. So yeah, very pleased to be here, and I'm sure I will make more introductions in answer to your questions.
All right. So to kick things off, my first question would be this. Could you share with us and with the audience, what was the initial motivation to pursue a career in law? And whether there were any times early on in your career where you thought back and said this was the correct decision to make?
Yes, so I guess my first memory about pursuing a career in law was when I was very young as a child. My father said I was very argumentative, and so I would be wasted if I wasn't a lawyer, because then I would get paid to argue with people. So that's one of my first memories of why I ended up being a lawyer. And then as a teenager, I really suddenly developed a love of reading. Like I would just pick up any and every type of book, and once I was 50 pages in, I would be hooked. And I think that's quite an important hobby, passion. If you love reading, then it makes being a lawyer very easy, because you oftentimes spend morning to night just reading materials in your cases. And because I never got bored, as soon as I got into a subject, it wasn't boring anymore. It'd be really interesting, and I want to find out more and more about it. So that made it easy, particularly being a disputes lawyer, because you do, as you know, have a range of cases from all types of jurisdictions, all types of subject matters. So that's how I ended up choosing a career in law. I did also really love the international aspects of arbitration. And so that sort of made me focus more on arbitration. I like the idea that you weren't sort of restricted to the jurisdiction where you're qualified in. You could be counsel in most arbitration proceedings around the world. so long as you had assistance on the governing law, as arbitrator, likewise. So I really like that, and which is why, as a lawyer, I pivoted towards arbitration.
Right, and you mentioned that your practice spanned almost 5 different regions or
Yes.
different countries. It's very interesting. If I were to ask you, how would you characterize your professional journey so far? Especially since you mentioned that you began practice in a law firm. You were there for almost 2 decades.
Yeah, more than 2 decades.
Right. Before you moved on to a role as an independent arbitrator, and now you're also with an arbitral institution. Done that in the past as well, of course. But how exactly would you characterize your journey, and any defining points in each of those stages?
Yes. There are so many highlights across 25 years. It's really hard to narrow it down just to a few. But I think I'm a dying breed of lawyers because I stayed in the same law firm for 25 years. So when I first entered the profession in the early 2000s, or late 1990s, that was quite common. Like when I went to, so the firm that I stayed with this whole time, because I love being part of the firm, was Herbert Smith when I joined, then Herbert Smith Freehills, now Herbert Smith Freehills Kramer. And when I joined, all the partners you met were what we called lifers. And so what that meant was you grew up with these people. In many ways, your colleagues were not just your colleagues, they were as close to you as your family members and your closest friends. They kind of went through thick and thin with you along the way. So that kind of environment is very unique, I think, and increasingly rare these days. But it enabled you to really work on honing your skills in your chosen field of expertise, because I guess you're not worried so much about moving firms and learning a new office culture and getting close to people. These are just people that you grew up with and you're doing cases with day in, day out, and you've known them for decades. So that's very good. And in terms of career-defining moments, I want to single out my experience, the 2 or 3 years when I was a senior associate, as a particularly important part of my career. A lot of people say the transition to being a partner, and it being in the partnership is the most important. But actually, I think as a senior associate, it may be more important, because that's when you really become good at what you do as a lawyer. And you get to practice being a lawyer. And I compare it to, being an octopus, where suddenly instead of having just a set, like 2 hands as a human being, you've got 8, because you know how the firms work. You know who can support you, from paralegal to trainee to junior associate to partner. You've got a good relationship with the client because you're the one who's day to day running the show. And so you can really kind of manage and execute and move the case forward, and you're the sort of big brain behind the strategy of the case. Of course, the partner swans in and, fronts the meeting or deals with the advocacy at the hearing, but everyone who knows the industry really knows that it's the senior associate that's like kind of the backbone of the entire operation. So I love that period, and I always tell juniors, that is something to look forward to. And when you get there, to really spend those years like honing your craft, because you're never going to be a better lawyer than you are when you're a senior associate. Because once you become a partner, and maybe we can talk about that as well, it's a different job. It's much more about building the business, making sure the P&L is strong. You've got to feed your team. You've got to make sure your clients cared for, not as in, they get the best drafting, which is important, but, cared for psychologically. You need to, worry about things like their job security, how they're going to report to their bosses and their shareholders and that sort of thing. So, which is also very interesting and a fun part of the job, but not so much the tech, it's not so important to and help with the technical legal aspects of winning the case. So yeah, maybe I'll pause there.
All right. So no, it's good to see you give senior associates their due credit.
Oh,
And
absolutely.
also what you mentioned about being loyal to one firm for a long time. It's very it's a good point to make at this time, because attrition rates at law firms is really high these days.
Absolutely.
And the fact that you mentioned about the working environment, if I always say this to my colleagues as well, if you spend so much of your time at work, so if you like the people around you, things
Yes.
become a lot easier, right?
Yes.
Now, moving on to the next question, who have been your role models or inspirations, maybe in this field or outside this field? And is there any particular piece of advice that you received that still holds strong even today?
Yeah. So there have been several people, there have been many, many people, I should say, that helped me along my journey, without whom I probably wouldn't be where I am. But the people who've helped me the most and really stay in my mind, I'm going to identify three at this stage. So Paula Hodges, KC, who also recently retired, was just an incredible head of department for arbitration. You know, when in early 2000s, when Herbert Smith decided to make the decision quite early for them, whereas it's very common now to split litigation and arbitration and have people specialize only in arbitration. She was the head of the group at the time, and at a time when it was very, less common to have female partners, let alone female heads of department. And she was quite visionary in thinking about what arbitration would mean in the future, and she was quite visionary in suggesting to me, I still remember the meeting in her office where she said, why don't you go out to China and be a partner there? And this was at a stage where international firms were just going into China and opening an office, and the first lawyers that would go would be like IPO lawyers. So no one had a disputes department, and she was asking me to go, and it was a big adventure, really paid off, as you will see from my career, because I do mostly China-related cases now. So she's very important. The next person, Sonia Leidecker, she was very senior in management of the firm. She was the head of the disputes department, which is like, a third to a half of the firm, because the firm is very famous for disputes. And she pushed me down the road of law firm management. So because of her inspiration, I became managing partner for the China offices and then for the Asia offices. So I think without her, I wouldn't have taken that role. And last but not least, I must mention Justin D'Agostino. He's currently and has been for about 5 or 6 years the CEO of the firm. Of course, when I knew him, he was just a 2-year PQE associate when I joined the office. So we've been through so much together over the years. He wasn't always the CEO. He was just a junior associate when I was a trainee. So we had loads of fun together. And because he was a bit more senior than me, he always gave me very good guidance. Probably most importantly, he introduced me to my husband about 20 years ago. So I owe him a lot. And he's been one of my sort of closest friends, even after retirement. So it's very nice when you have these lifers, you build these relationships that last post your departure from the firm. But, sorry, I'll just say one last thing about this question. Mm-hmm. The bit of advice that I got that stayed with me the most has come from a paralegal about 10 years ago who we had to let go in Shanghai when we were doing a round of retrenchment because the business was not doing very well at the time. And, I'm going up to this girl and I'm feeling very terrible about having to let her go. And then she says to me, she was the brave one, and she said to me, don't worry, there's no such thing as winning or losing. There's only winning or learning. So every experience is either a winning experience or you learn from it. And I just couldn't believe how incredible her attitude to life was, that even on such a sort of in many ways sad and devastating thing as losing your job, you can be positive and take it as a learning experience. So I really learned from her. And I take that phrase with me, through everything I go through, which is, sometimes positive and sometimes negative. And rather than thinking about something as, oh, this terrible thing happened to me, I think, where is the angle where I can learn from it?
So winning and learning, I think we have got the thumbnail for our podcast. But the next question is going to be slightly philosophical.
Okay.
If there was something that you could go back in time and alter or change, something that you could do differently, what would that be?
Yeah. Yeah, I mean, that's quite a tough one for me. I've had my highs and lows, like everyone else. So it's not like everything always goes swimmingly. But having said that, I'm not sure, maybe it's because of the winning or learning motto. I'm not sure I would change it, even the sort of really horrible bits. But I guess if I had to pick, I guess I would go back and not take things so hard, not be so hard on myself when things don't go well. So there was this one incident. The Singapore River has a special meaning for me. This is going to sound very bad. I wasn't very serious about it, but I left an arbitration hearing. I can't remember, it was like day 5 of 10 or something, in the middle of a hearing. And I had a particularly disastrous cross-examination. Like, it was supposed to be quite a minor witness who was talking on a kind of narrow subject. And it was one of those I didn't give much thought to. I thought, I should be done with him in about an hour. And I got it was a technical issue. So I got a lot of support from the engineers from my client side who were very confident about their position. And so because it was a minor witness, because they were very confident, I didn't really test it, which I should have. And he totally destroyed me on cross-examination rather than the other way around. And after that, as I was walking back to the hotel, I just wanted to throw myself in the river, And that's not the only example of a bad day in court. There have been others. And I take it very personally, very, very personally. And the next morning, you still have like day 6 to 10 or whatever. And you just really have to scoop yourself off the ground, pretend it never happened, go in there, you live to fight another day. Now with more of these bad experiences under my belt, I think I can get through that more easily and not have like full night of just replaying the horrible scenes in my mind. But you can't really go back and change that, because until you learn your lesson and live through that, you can't really do that. Up until that point, cross-examinations generally have gone quite well. So I was like thinking, I'm like a really hotshot cross-examiner. But actually, that's not true. These things happen to everyone, and you need to be prepared for the worst case scenario. And, every time my juniors used to ask me for some tips on cross-examination, I'm like, you just need to be prepared for every single thing that's going to come up of your witness's mouth. Don't just, have the script in your head, like they're going to say this and I'm going to ask that and then they're going to say this. It never happens like that. It's like taming a wild horse. Live and learn.
Fair enough.
Win and learn.
Right. Now, you are qualified as a lawyer in both Hong Kong and as well as the England and Wales. You're a solicitor in England and Wales.
Yeah.
Could you tell our audience exactly when you pursued those 2 qualifications?
Yep.
And the advantages of being qualified in more than one jurisdiction? Is that something that you would, is that advice that you would give to the younger generation to try and get qualified in jurisdiction outside their home jurisdiction as well?
Yeah. I absolutely 100% would, if you are planning to have a career in arbitration. Arbitration, part of the name is international. International arbitration as a practice area, the more international you are, the more you can show not just qualifications, but other types of skill sets that set you up for internationalism, like languages that you speak, like countries you've lived in. And, if you haven't had the privilege of living in other countries, then go and find secondment opportunities, work for a multinational, work for an international arbitration institution. There's so many things you can do, but getting a second qualification, shows your commitment to being more international in your approach, in your outlook, in your appreciation of legal systems. I think it's very important. I got my qualifications in England and Wales 2003, and I went the long way and did the whole training contract and all that. And then in Hong Kong in 2014, which was just an exam. At the time it was only one exam, but now I think it's multiple exams. So countries are making it more difficult, generally speaking, to qualify, but it's still very much worth it. My understanding, although I haven't been through it myself, is that England and Wales is making it easy, or has made it somewhat easier to qualify, because it's appreciated that it doesn't want English law to, fall in importance in the world. And it's realized that the reason why English law is so important is that there's so many English law qualified lawyers all around the world, and common law qualified lawyers. So if that's correct, based on what I've heard, then I think there are opportunities to get English law qualified. And, for Malaysians, for example, it shouldn't be too difficult, because Malaysian law is based, is a common law, etc. And there's a lot of similarities.
But just a quick follow-up to that. What about your appointments as an arbitrator? Do you think that it holds you in good stead, the fact that you're qualified in more than one jurisdiction? For example, there's a party, there's a Hong Kong party, another UK party trying to arbitrate a dispute, and they see someone who's duly qualified. Do they think? Do you think that's some sort of an advantage?
Yes. Yes, it's an advantage in some cases. So in some cases, they want an English qualified lawyer who's not an English national or UK national. I mean, arbitration is very much mix and match. And from an institutional perspective that, there's the neutral nationality rule, and then there's the language rule. And the more you can tick the boxes that the institutions are looking for, the better. So the more governing laws you're familiar with, the better. But that's not to say that just because you're not qualified in one or another jurisdiction, then you should give up. I think Malaysians are slower to grasp that being qualified in Malaysia is very powerful, because you can hear and be advocate and counsel on cases involving Singapore law, involving Hong Kong law and English law, relatively easily, because there's a lot of similarities. So, for example, I sit on a lot of Singapore law governed tribunals, and no one kind of bats an eyelid about that, because they think I've got enough experience, and with Singapore Council supporting me with their submissions, that would be good enough. I also sit on a lot of China law governed cases, even though I'm not Chinese law qualified, because the parties and the institution believe, because I have practiced in Shanghai and Beijing, I'm quite familiar with the legal principles there. And, I usually have a co-arbitrator who is qualified there, and counsel who's qualified there to support me as well.
Right. So you are now the Vice President of the ICC Court of Arbitration. You have in the past been a member of the court of the LCIA.
Yes.
You were also on the advisory board of the THAC. In your opinion, what truly makes an arbitral institution effective in today's day and age?
I guess it would depend on what the arbitration institution's KPIs are, their objectives. So based on the experiences that you mentioned, I'm guessing that most arbitration institutions want to get more cases registered, administer more cases, get the bigger market share, convince more users to use the institutions to administer their arbitrations. If that is the objective, then I would say internationalism and neutrality is really, really important, because parties, and I'm sort of wearing my hat as counsel when I used to advise clients, companies about which arbitration institution to go for. They can be very suspicious, even a kind of an impression that they might not get a fair hearing will stress them out a lot. So the reputation of the institution is very important. It has to be, and they have to be truly international. I think that's very important. You don't have to be international if your big selling point is we know. So to give you an example, CTAC has tens of thousands of domestic cases. Their kind of original selling point and original reason for success is that we're the biggest and the best in China, and we know all sorts of Chinese disputes. We have, tons of Chinese arbitrators on our panel. That's why you go to them. But now they are trying to pivot and get disputes where the other party is not Chinese, and trying to persuade them that we will still do a good job on your cases, in which case, they have to internationalize. They have to have a lot of international arbitrators. They have to be completely fluent in English, the secretariat, et cetera, et cetera. So yeah, you can see where I'm going. But, having people like you on the secretariat is an acknowledgement that that's, very important. It's not just about the arbitrators. It's not about, the registrar or the secretary general. It's about case managers. It's about counsel. It's about arbitrators.
There's an entire ecosystem that is feeding a particular institution.
Yeah. Being an arbitration institute, I'm just sort of testing out this analogy. It just came to my head, this metaphor. It's a little bit like being an airport, right? You're not just so the Malaysian airport, you're not just servicing Malaysians. What you're trying to do is make it a hub. You're trying to get people who've got nothing to do with Malaysia to transit here. Maybe, stop over for a few days on their way somewhere else, spend some money, stay in hotels. Arbitration Institute isn't dissimilar. So to do that, you need to have really international, cabin crew. They can speak all sorts of languages. They can make people feel comfortable. They can field random questions from people who are, a bit scared and unsure because they're in a new place and they don't know how things work. So it's a little bit like that.
That is actually a pretty good analogy. Now, with your extensive practice and the various leadership roles that you have had in institutions, how do you manage, the demands on your time? Are there any tips that you have that you could share with our younger practitioners? Some things that you do to ensure that you don't miss something?
Yeah, I get asked that a lot, and I'm afraid I don't have a silver bullet, so it's going to be a bit disappointing for people. Private practice was very demanding, and there's just you always have a to-do list, as long as a mile. And it's very difficult to have good work-life balance and be a very, a top lawyer, successful partner, bringing in the clients, executing the cases to a high degree of success, and oftentimes managing other lawyers. That's a big docket. That's your load is very, very full, and so in recent years in my career, I've sort of adopted. First of all, I've cancelled giving myself New Year's resolutions. I don't do that anymore. For the last, I don't know, at least 5 years, maybe longer than that, maybe 7 or 8 years, my New Year's resolution has always been do fewer things, do them better. That's the only resolution I'll have. And yeah, I just find that I enjoy life more when when I'm not trying to achieve 10 things, but only trying to achieve 5 things, but doing them, giving them proper time, doing them well. So yeah, if you end up being thing number 6 to 10 that gets a no from me, I'm very sorry. But that's because I'm trying to do justice to 1 to 5. So I don't take on that many cases. I take on what I feel I can manage and do to a high degree of satisfaction. Yeah.
Right.
That's my tip.
Have you tried eating grapes at 10 o'clock under the table? I believe that's a new custom that people are following.
No.
It helps you, it's like manifesting your New Year resolutions. Apparently, it makes them come true.
Oh, really?
When the clock strikes 12, you're supposed to have grapes under the table.
Just one, or?
I mean, as many as your wishes, I guess, or
When
as
you-
many as your resolutions.
When you were saying that, I was, my kind of, maybe it goes somewhat towards the work-life balance thing. My immediate thought was, ooh, grapes are very sugary. And if you have them at midnight, that's probably very bad for your blood sugar.
But I believe it's become quite a practice. Popular so here in Malaysia, but also in Europe.
Really?
If you go around New Year's Eve to the local grocery store, you will see that they have run out of grapes.
Oh, okay. Well, I'm gonna have to Google the origins of that practice as soon as we finish.
All right. Could you share, besides work, what are some of your interests and hobbies? Is there something that you do outside of work that helps you recharge and recuperate?
Yes. So some people find this weird. I'm not sure why. So outside of work, I play a lot of table tennis. I'm very into it. Sometimes I play 3 or 4 times a week for like 2 hours at a time. And I hasten to add, I've only started playing that much after I retired from private practice. I also really like foraging for wild foods. Now, people who find this out get a bit scared because, there have been all sorts of random cases of people who've got mushroom poisoning and died from it because they didn't know what they were picking. So I hasten to add, I'm very, very careful. But yeah, that's one of my hobbies, which some people find a bit weird. But I like, we're very fortunate to have a house in the countryside where this sort of thing is very common and easy to do and all of that. So yeah, so those are 2 of my hobbies.
Right, okay. We in fact have a table tennis room here at the AIAC.
No, you didn't tell me.
So the next time that you're here, probably
Yes.
we could try our hand at a round of
Oh,
table tennis.
definitely. I think you
that'll be
should. Yeah. Now that I know that, I'll be here all the time.
lovely.
And
Okay.
you should have you seen Top Gear?
Yes, of
the
course.
TV show?
Yes, it was my favorite.
Yes.
Uh.
So what you should do is you should have like arbitrators play a game with each other and then have the rankings.
Right. That's actually a very good idea.
then-
Like they have for the
We're
lap
talking-
records.
Yeah, exactly. And then all of the famous arbitrators will come because they want to get to the top.
Get their name.
And then whilst they're here, you can do more video podcasts with them.
That's actually a very good idea. So this comes to my last question now. What message or advice would you like to share with the young practitioners, especially those who are looking to build a career in disputes and international arbitration?
So one of the perhaps slight downsides of being in the same firm for my whole career is that you start to have this impression that I don't know why, because it doesn't make sense, that someone is looking out for you and making sure that you progress in your career up the food chain, up the ladder. And I always tell juniors that I work with, whether they ask for my advice on this or not, that the firm doesn't have a brain where it's thinking like, oh, we haven't promoted Vishnu in like a couple of years. We should look out for him because he works very hard. He stays here every night till like 9 p.m. We should promote him. No, there isn't this person whose job it is to do that. Everyone's just got, as I said, a to-do list a mile long, and they're just trying to get through their list. And you are not automatically on someone's list or even on the top of someone's list. Of course, you will, through your career, have very nice bosses who want to do the right thing by you, but it's really not, part of their mandate. So it's really important for the individual to take charge of their careers, to think for themselves, like, where do I want to be in 2 years' time? Or this month, I spent an entire month working on reference schedules. Do I want to keep working on reference schedules next month? If I don't want to be, then what should I be saying to the partner or this other partner who's got a very interesting international case involving Indonesia, which I have never done, a case on. So you need to be kind of planning this out. No one is going to plan it for you, but everyone's got goodwill to help people succeed. You know, as a partner, I want an associate who's well balanced, who's in terms of having done reference schedules as well as witness statements, expert reports, et cetera, et cetera. But I don't have time to make sure they tick all the boxes. They need to go, you know, I've been an associate for 5 years and I've never done, I don't know, a security for cost application. Can you keep me in mind? Or I noticed there's this procedure in this other case. Can I get involved in that? I know it's tricky because it's political and people have their favorites and all of that, but if you don't plan for yourself, then you're just not going to get anywhere. You'll suddenly become, you know, the queen of reference schedules because you'll get really good at it, and then that's what they keep giving you because you're very good at it.
Right. Okay. So
that's my advice.
That's very interesting, and I'm
that
sure
and the top gear for ping pong advice that I'm giving the AIAC.
also winning and learning. So there are quite a few takeaways from this podcast. I just want to tell the audience that it's very kind on May's part to do this. This was a bit last minute, but it just so happened that she was here in Malaysia, and we snapped up the opportunity and got her on board. I hope you've enjoyed this conversation as much as we have. Thank you so much for being our guest.
My pleasure. Thank you for inviting me.